Good evening, chat. Hello. Sorry, a couple minutes late. I told 2.0 I'd take care of dinner and I kind of scrambled, got a little sidetracked on that. So that's entirely my fault there. But we are ready to address an oral argument had this week, and that is Smith and Wesson et al., meaning Barrett, Glock, Beretta, Ruger. You may have heard of them, Colt, versus the Estados Unidos Mexicano, also known as the Mexican government. Now, what is actually going on here? Well, and actually, before we get too far, my name is Sean, also known as Potentially Criminal. Welcome to the show. I'm an attorney in the Cleveland, Ohio area, and today we are going to get into this and what happened to, yeah, that's weird. Like, it kind of killed my preset. That kind of sucked. Huh. There we go. That's weird. I didn't mess with any of this stuff, but it did it. Anyways, we're going to cover this situation here. So the lawsuit is the government of Mexico sued all these U.S. gun manufacturers and U.S. gun companies. And their argument ultimately was, and I'm not joking when I tell you this, guys, like this is 100% their arguments. And we covered this previously. So the argument is that they've decided these gun companies have helped the cartels because they're no longer selling guns. They know where they're going and they don't care about what's happening. And yes, they really think these companies have basically conspired to let this happen. Remember everything going on south of the border. Yes. Are there guns going south? Yes. Are there a ton of guns showing up in the cartel's hands, though, that are military assistants to Mexico and owners of the belonging to the Mexican military? Yes. So it's like you can take America out of this and they're going to get their guns still. Now, the Mexican government claims the Protection of Lawful Commerce and Arms Act, the PLCAA, doesn't apply. So they sued and they were in Massachusetts and they lost. The district court said, hey, it does apply to gun companies aren't liable because criminals are misusing the products. It's not their fault. The law applies. Now, the First Circuit reversed. And they said because Mexico hadn't stated a claim about that. They're saying their business practices aided and embedded the firearms trafficking. So it wasn't that people were misusing their guns. It's their policies were enabling things to happen. So that's how the First Circuit reversed. Since then, Smith and Wesson and the U.S. gun industry went up to the Supreme Court. They got certiorari, and they had oral arguments on the 4th. And there's two issues before the court. There are two issues before the court. The first issue is whether the production and sale of firearms in the United States is the proximate cause of alleged injuries to the Mexican government because of drug cartel violence. And then number two, dos, if you are from Estados Unidos Mexicanos, is whether the production and sale of firearms in the United States amounts to aiding and abetting illegal arms trafficking because these companies know that some of their products will be trafficked. And that's the entirety of the Mexican government's argument. So, yeah. Pretty much, chat. You're like, wait, what? And yeah, I agree. This is nonsense, but the Supreme Court is going to do it. And we're going to see what happens here. Also, chat, we are live tonight on Rumble should be up now. Sorry, chat. We are live on Rumble, Twitter, and YouTube. So welcome, everybody. Rumble should be up right now. So let's get started here. I'm going to check real quick to say check some things here real quick. Chugi Show says, late because I couldn't decide if the bacon on a sandwich was Canadian or just thick. No, actually, made a nice little taco salad bowl for 2.0 myself. Tech Guy South is a new member. Thank you for being a member, doing your part, joining up personally, joining in that crusade to take care of the Greys. Two Scoops of Destroyer says, so they're suing manufacturers instead of the ATF and CIA for putting the guns in the cartel's hands. I mean, yeah. And then I Hate Yankees has been a member for 2 months. Thank you. says tax remittances if they keep this shit up. I agree. You want to break the backs? You want to buck break Central and South America? Tax remittances. All the money going south. Ooh, child. Stacy says, I'm up to 250 pounds on leg press. Congratulations. Keep up the good work. And Jefferson Post says, oh, God, of course I choose Massachusetts for the venue. Remember, Smith & Wesson is, at the time, was headquartered in Massachusetts. So that's part of the reason why they went there. So anyways, we are ready to go. It is time. So, Whiskey says, we are live. Nobody told us. And I put the word out. Also, guys, if you go on the locals, you can see pictures of Clyde and Laney from early on. So here we go. It is time to get started. We're going to use C-SPAN. You know, when we listen to other arguments and they have like the pictures of the heads of the justices popping up, they're not available. For some reason, they didn't do it on this one, which is a little frustrating because while I may know who's who, you guys won't. But we have closed captioning at least, so we can figure out what's going on here. So, and here we go. So we are going to
Smith & Wesson brand.
Now we're gonna have to pound up the volume on this. Let me know if this is not gonna work here, chat. I will actually, you know what? We'll do let me see here. We should be able to get the we should be able to get this here. Let's see if this should be able to, I think there'll be closed captioning here. Let's see if I can get this. Okay. There is no transcript here, so we're just gonna have to bump the sound up. If the sound dies at all, let me know, chat, but I'm gonna boost it real quick here.
Versus Estados Unidos.
Okay, there we go. It's getting there. So hold on, we'll put it up some more.
Mexicanos. Mr. Francisco.
Mr. Chief Justice, and may it please the court. Mexico asserts that American firearms companies are responsible for cartel violence ravaging Mexico. Its theory is that federally licensed manufacturers sell firearms to licensed distributors, who sell to licensed retailers, a small percentage of whom sell to straw purchasers, some of whom transfer to smugglers, who then smuggle them into Mexico, hand them over to cartels, who in turn use them to commit murder and mayhem, all of which requires the government of Mexico to spend money. Needless to say, no case in American history supports that theory, and it's squarely foreclosed by the Protection of Lawful Commerce in Arms Act.
Actually, chat, somebody brought up, I forgot Oyes. We're going to do Oyes instead because we've got the judges here and we can see what's going on. So we're going to switch over to this. I forgot about this, so here we go. So you'll see their heads pop up when people are talking. And then, you know, we're going to go from there. All right, chat. So here we go. Let's see if you guys can hear it.
We'll hear argument this morning in case 23.
That theory.
1, Smith & Wesson brands versus Estados Unidos Mexicanos. Mr. Francisco.
Mr. Chief Justice, and may it please the court.
Good
Mexico
point.
asserts that American
Good
firearms companies are responsible for cartel violence ravaging Mexico. Its theory is that federally licensed manufacturers sell firearms to licensed distributors, who sell to licensed retailers, a small percentage of whom sell to straw purchasers, some of whom transfer to smugglers, who then smuggle them into Mexico, hand them over to cartels, who in turn use them to commit murder and mayhem, all of which requires the government of Mexico to spend money. Needless to say, no case in American history supports that theory, and it's squarely foreclosed by the Protection of Lawful Commerce in Arms Act. As to proximate cause, this court has repeatedly said there must be a direct relationship between the defendant's conduct and the plaintiff's injury. But no such relationship exists if plaintiff's injury is caused by multiple intervening independent crimes committed by foreign criminals on foreign soil to inflict harm on a foreign sovereign. As to aiding and abetting, Mexico doesn't identify a specific crime, criminal, or criminal enterprise that defendants supposedly helped. Instead, it asserts that defendants are liable for every illegal sale by every retailer in America because they know that a small percentage of firearms are sold illegally and don't do more to stop it. Again, no case in history supports that theory. Indeed, if Mexico is right, then every law enforcement organization in America has missed the largest criminal conspiracy in history operating right under their nose, and Budweiser is liable for every accident caused by underage drinkers, since it knows that teenagers will buy beer, drive drunk, and crash. The First Circuit gravely erred in embracing that implausible theory and should be reversed. I welcome your questions.
Mr. Francisco, as to the predicate exception, which federal or state law is petitioner reputed to have violated?
So my understanding, Your Honor, is that there
Right out the gate, chat. Uncle Clarence asking the great question. What law has been broken? What law has been broken? Very important. What law has been broken here? What law have we broken? Let me know. If you guys can't read the text, let me know. But yes, what law has been broken?
invoking the federal aiding and abetting statute to argue that we have aided and abetted the federal statutes that govern the sale of firearms. And they're alleging that retailers have knowingly sold firearms to straw purchasers. And
hold on, chat. What happened here? What the heck? Here we go. I don't know what the hell that was. We're going to keep going from here, guys. Sorry.
that we aided in abetting that knowing sale. That actually raises a very important question about their allegation of knowing. I don't think it's relevant because I'm willing to even assume a certain level of knowledge. I don't think it matters. But their theory of knowledge is that we actually know that retailers are selling illegally. I'd actually urge you to look at that 2010 Washington Post article that they incorporate into their complaint. That article talks about a particular retailer called Lone Wolf. In 2010, it was the #1 seller of firearms that were found in Mexican crime gun scenes. And in that article, you actually have a quote from ATF that says that ATF has no basis to believe that Lone Wolf is doing anything illegal or wrong. Well, if the government doesn't know, how are we supposed to know? It reflects this convoluted theory that simply because the gun is found in Mexico can be traced back to a retailer. That means the retailer necessarily sold it illegally, and that we know that the retailer sold it illegally.
Would this be a different case if there was a specific federal or state statute that you were known to have violated?
Your Honor,
Okay, Nate, you're asking what is a straw purchase? A straw purchase is where person A buys a gun for person B, and that person, the way the ATF is typically describing it, let's say person A is a felon. He goes up to person B and says, will you buy a gun for me? When you fill out a 4473, you state, I'm the person buying this gun and it's for me only. Well, person A gives person B the money, person B buys the gun and turns around and gives it to person A. Now, a lot of times the way this will happen is guys with felonies will bring their girlfriends into the gun store and they'll be telling her what kind of gun to buy. Now, this has been extended to even people who are legally, like person A and person B. Hypothetically, let's say A and B are both legally allowed to own a gun. There's case law now from the Supreme Court where even if A and B can both own a gun, if A gets B to buy the gun for him, because in this case, person B has the ability to get a discount or a sale price for a gun, that's still a straw purchase. So it's basically buying a gun for someone else as an adult. There's exceptions. Obviously, you're dealing with children because obviously, like it's not like you just generally, like if you ever want to get a gun for somebody, you get them a gift certificate to the gun store is probably the best way to do it. So, yeah. So that would be my recommendation.
would be a different case. I would want to know more because I still think that depending on what they alleged, I would have very strong arguments on proximate cause and aiding and abetting liability, but it would certainly be a different case.
Well, the reason I ask is because the exception is for knowingly violating a state or federal statute, and it would seem helpful in determining.
For the PLCCA, Chad, if you violate a statute, knowingly violate a statute, yes, then you have no protection under the PLCAA.
Aiding and abetting, and then eventually proximate cause if that comes up, if you knew which statute we were dealing with.
So the complaint is a little bit vague on this. To the extent I understand it, they're looking at federal statutes that restrict the knowing sale of firearms to people who aren't authorized to purchase them. And then they're invoking the criminal federal aiding and abetting statute to claim that we're then liable for those illegal sales. I'm willing to assume for the sake of argument that that's valid because I don't think they come anywhere close to establishing aiding and abetting liability. And even if they did, I don't think they come anywhere close to establishing proximate cause.
I'm sorry, counsel, but exactly what role, I had difficulty telling from your brief, does foreseeability play in your proximate cause analysis?
So as this court has made clear in a number of cases, it's not that foreseeability is irrelevant. It's that foreseeability alone is not the standard. So it's necessary but not sufficient. In addition, there has to be a direct relationship between the defendant's conduct and the plaintiff's injury. And Your Honor, I think that the plurality opinion you authored in the Hemi group is directly on point. That is where a case where the plurality held that the city of New York couldn't sue a cigarette retailer for not filing the tax reports in order for the city to recover its lost tax revenue, because in between the city's injury of lost tax revenue and the retailer's failure to file the reports stood the citizens of New York who illegally failed to pay their taxes. And that broke the chain. This is a much easier case. Here we don't have just one intervening independent crime. We have a multitude of intervening independent crimes. So even if they could establish aiding and abetting liability, and I don't think they come even close under Twitter, they couldn't establish proximate cause, which is the other requirement here.
Counselor, it seems to me that the cases are a mess on proximate cause. And you're asking us in this case to choose among a variety of different explanations of it. I think, however, I try to break this down. I think their complaint is saying that the violation is selling to straw purchasers. And I think the risk in selling to a straw purchaser, and that's the known risk of that violation, is that that straw purchaser.
But you don't know it's a straw purchaser at the time you sell it. The guy, if you sign the form, he's the one that lies. You don't know anything until he buys the goddamn thing.
Purchaser is giving or selling the gun to someone who can't possess it because the likelihood is that they're going to use that gun illegally.
How would you know that?
That's the risk of the violation. And I think that that's what their complaint says, which is, now, I'm going to put aside the lack of the conclusory allegations. And I agree with your point that they don't really tell us which dealers are doing this, who they're aiding and abetting. There may be a lot of conclusory allegations, but the theory, I think, that they're advocating is if you're selling to a straw purchaser, that's, you know, that the risk is that they're giving it or selling it to people who are going to commit crimes. Here, the Mexican cartel. So I don't know if this is a proximate cause case or it really is what you say it's not, or that the allegations are insufficient for aiding and abetting. I think for us to go into proximate cause opens up a Pandora's box.
So I want to take one step back, Your Honor, because they're not alleging that my clients engaged in any illegal retail sale. None of my clients actually sell to consumers.
No, the complaint says they aided and abetted. Justice Thomas asks you, what violation? I believe the violation they claim is that the dealers are selling to straw buyers.
Sure. And I just wanted to be clear that I think that the chain of causation, I think it's relevant both to proximate cause and aiding and abetting. I think that the chain of causation under the statute doesn't start at the illegal sale because we aren't alleged to have engaged in an illegal sale. It starts with the conduct that they allege constitutes aiding and abetting the illegal sale, which is the way that we manufacture and distribute our firearms. But I also think that's relevant to aiding and abetting liability because we're not alleged to have aided and abetted any cartels or any illegal purchaser. We're alleged, in this case at least as they presented it here, to have aided and abetted the retailers. And so they have to carry the argument that somehow we're liable for every illegal retail sale in America because we know that some small percentage of retailers may sell the firearms illegally and don't do more. Now I dispute
now, Mr.
that.
Francisco, I just want to pause there for a second. Sorry to interrupt you, but just to follow up on Justice Sotomayor's question, put aside aiding and abetting. Assume for the moment that you did aid and abet the sales. Your clients aided and abetted the sale of guns to bad apple dealers, ones they knew or intended to even for them to sell on to people in Mexico doing bad things. They knew that. They knew all of that. How would you not have proximate cause in that hypothetical?
So sure, Your Honor, and that is a huge assumption. But even accepting that assumption, for the same reason there was no proximate cause in Hemi Group. Even if you assume that we're on the hook for that illegal retail sale, you still have a multitude of independent crimes in between that sale and injury to Mexico. You have the straw purchaser that gives it to the actual purchaser. You have a smuggle across an international border.
I understand, but my hypothetical assumes that you know all that. Your clients know all of that, maybe even intended. Now, whether there are allegations of this complaint sufficient, put that aside. But if you know or intend all of that, then what?
I still don't think that establishes proximate cause when you have an intervening independent crime. And I'll point you to Hemi Group, Your Honor.
Oh, yeah.
In Hemi Group, the underlying statute was the filing of the tax reports. The entire purpose of the tax reports was to allow governmental entities to collect tax revenue from cigarette sales online that weren't otherwise subject to sales taxes. But the plurality held that that independent intervening act still broke proximate cause. I think it goes back to the court's 1876 decision in the St. Paul Railway case, where you made clear that if there is a sufficient and independent cause. Your Honor, I think of the court as a collective body that operates across time. And it made clear.
Gorsuch doesn't believe that.
Yeah, I do.
And it made quite clear way back in 1876 when you do have that, and I'm quoting, a sufficient and independent cause operating between the wrong and the injury, that does break the chain of causation.
In chat, we were talking about this here. Proximate cause is all about like the actual harm. You know, the direct cause, like, but for this happening and like the whole chain of events you can follow, this was a proximate and direct cause. In this case, we have people who are illegally buying the gun. They illegally traffic the guns. They illegally take them across the border, and then they go commit crimes with the guns and give them to people who are now considered terrorist organizations. That's 4 separate crimes. That's 4 layers that you can't have the option there for. So this is yeah, John Roberts is insufferable, but there's some good points here. I mean, but there's not only so much that like chat, they're asking him questions, but like they're not really hammering him because they're kind of like, yeah, we kind of have to go with you here. So yes, Nick Ricciardi told Mac about guns and smuggle them across the Mexican border.
Even if it's eminently foreseeable, just like many, many, many years later in the Hemi Group case, the court concluded the same, even though it was eminently foreseeable that the retailer's failure to file the tax reports could lead to lost tax revenue.
Mr. Francisco, can I just put a point on this because I want to make sure I understand the.
Oh, look, Amy Comey Barrett's got a fucking comment she wants to talk about. Where were you before, bitch?
The line of questions you've been asked. So it seems to me, as Justice Thomas began, that when we're talking about the statute that was the violation at the beginning for the predicate, it has to be a statute that was specifically applicable to the sale or marketing of the product. the gun.
Yes.
Justice Sotomayor asked you. So that's the retailer selling it to the bad guy, right?
Yes.
Okay. That's where the proximate cause inquiry comes in. Your client, the theory, right? The theory is that your client under example 2, has aided and abetted as the manufacturer. Proximate cause doesn't appear in that portion of the statute. It's only in the predicate portion. So if we accept that framing of the theory, the framing of the complaint, we're really only asking about proximate cause, as Justice Gorsuch was asking you, between the retailer, the sale, and the harm ultimately caused to Mexico. And then we're looking at the chain of events that you're talking about right now. Sale to the bad guy, smuggled across the border, misuse.
So I think I have 2 responses, Your Honor. The first is I actually disagree with how you framed it, but the second is even if I accept how you framed it, I still think there's no proximate cause. The statute says that there has to be proximate cause between our violation and Mexico's injury. Our violation is not the illegal sale itself. It's the actions that we undertake to aid and abet it, the violative aiding and abetting conduct.
How does that fit in the statute, though?
Your Honor, because I think the statute says the statute requires that, sets forth the exception where a seller has knowingly violated an applicable statute and the violation, referring to the seller's violation.
But it's not just applicable statute, it's statute applicable to the sale or marketing of the product. So that seems to me to refer to a specific statute relating to this manufacture, sale, distribution of guns, not the aiding and abetting statute.
Well, I think it's got to refer to our violation. It refers back to the seller's violation. And here the seller hasn't specifically, and this maybe goes to the confusion that Justice Thomas pointed out, but the seller's violation is not the actual retail sale. We're not retail sellers.
Right.
The seller's violation here is the aiding and abetting of that retail sale. And I presume what they are invoking is the federal aiding and abetting statute, and they're trying to combine that with the actual specific sale. So I think there are all kinds of problems with their theory.
I guess I don't get that, Mr. Francisco. I mean, aiding and abetting is a form of vicarious liability. Why wouldn't you just say the aiding and abetting violation is the violation that is aided and abetted, which here, as Justice Barrett said, is the retail sale, say the sale to a straw purchaser?
Sure, Your Honor. I think I'm just trying to construct the statute properly, and I think as a matter of proper statutory construction, that's where you begin the proximate cause with our violation. But I don't really want to fight about it.
But your violation, as a matter of vicarious liability, is the violation that the retail seller it sells to the straw purchaser.
Your Honor, I'm not sure that's right, but again, I'm willing to assume for the sake of argument that it is right, because I still think that there's no proximate cause in between between the illegal retail sale and Mexico's injury off in Mexico, and I sure don't think that they've come anywhere close to establishing aiding and abetting liability. I've already explained why I think there are multiple independent crimes after the retail sale, in addition to the smuggle across an international border and the murder and mayhem committed independently by cartels in Mexico. To me, that is more than sufficient to break that chain. But in any event, I think that their theory of aiding and abetting liability is equally far-fetched. I think this is—
So with reference to aiding and abetting, could you just explain to me the sort of structure of this industry? Who are these distributors? Are they pass-through entities? Are they completely independent? Might they be both? What's the—
They're independent entities, Your Honor. It's possible that there might be some internal distribution, but by and large, a manufacturer makes the firearms. Then there are distributors who purchase the firearms from different manufacturers. Those distributors then sell firearms to retailers. Everyone in this chain is fully licensed. The retailers then are fully licensed and they sell to purchasers. The allegation is some small percentage of those sales are illegal, and we know it.
Is your representation that the manufacturers really only deal with the distributors, or do you understand the manufacturers to be looking at and paying attention to the dealers too?
Well, Your Honor, we're here on the complaint, and as far as the complaint alleges, it's simply the manufacturers going to the distributors going to the retailers.
Right, I'm asking from what you know of the industry and your client. Is the manufacturer essentially dealing with the dealers, or is there like a big roadblock
All right, so
which
we're
is in the form of the distributors.
we're outside of the complaint now, so I want to be very careful because I don't 100% know the answer to all of your question, but my understanding is that the manufacturers are not generally dealing with the retailers. You do have this tiered distribution chain where they're principally dealing with the distributors to the retailers, and so on. I think that the reason this is such an implausible aiding and abetting theory is because I actually think this case is a lot easier than the Twitter case in a number of different respects. First of all, Twitter, you actually had a specific criminal, ISIS. You had a specific crime, the Raina nightclub attack, and the defendants were actually providing that product to that criminal. You don't have any of that here. Instead, their theory is that by simply knowing that some percentage of retailers may be doing something illegal, that somehow puts us on the hook for everything that the retailers are doing. This is kind of a common law area. You'd think that they could cite one case that comes anywhere close to that, but they don't cite a single case.
Mr. Francesco, that's sort of what I'm a little confused about, and I wanted to focus on, which is, it seems to me that the core of your argument, both here and in your brief, has been that there's an implausible theory of aiding and abetting liability based on what they've alleged, and no case in American history supports this theory of liability, as if the question before us is evaluating the viability of Mexico's theory. And what I'm looking at is a statute that I
Get ready, guys. This is going to be breathtaking. We all know it.
think really makes this case about the scope of the predicate exception, that it's not really, an invitation to assess as a common law matter whether or not we think these facts allege aiding and abetting liability. Would you agree with me that the PLCAA statute takes off the table theories of tort with respect to these kinds of manufacturers, and really the only question is whether the statutory exception applies in this situation?
Well, I think I would agree that we're arguing about what the meaning of the statute is, but the statute can only be triggered if they find a violation that's the proximate cause. Here, the violation that they've
No, I
identified
understand, but
as
that
aiding and
proximate
abetting.
cause analysis is coming up in the context of an exception to the immunity that Congress has set forth. Is that right?
Sure, yeah.
And I think that's important because the scope of that exception may not be coterminous with our understanding of aiding and abetting liability as a common law principle. In other words, you look at Twitter, for example, and you say, okay, is this, what is being alleged here the same as aiding and abetting liability as it was set forth in that statute? That was a totally different statutory scheme. That statute, JASTA, in the Twitter case, was about allowing for these kinds of claims. And so what counts for aiding and abetting liability in Twitter may not be what Congress intended for this exception. I feel like we have to focus on where we actually are in this context in making this determination.
Well, Your Honor, I think that's where I might very much disagree with the theory that you're articulating. I think that they do have to show a violation. They've alleged it's aiding and abetting. There's no aiding and abetting in the air. What Twitter purported to do was look at traditional aiding and abetting principles.
I understand, but Twitter was a different kind of statute. We have said that, when we're doing statutory interpretation, when we're thinking about aiding and abetting liability, it may not be the same in every statutory scheme. And I guess what I'm just trying to, this is not supposed to be like a statement that is necessarily against your position. I'm just trying to understand the framing of this. It seems to me this is a statutory interpretation question about the meaning of what the predicate exception says, knowingly violated a state or federal statute. Aiding and abetting is in the examples. It's not even in the actual core statutory statement of what would qualify. So shouldn't we be focused more on trying to understand what Congress meant when it was accepting, you say narrowly, a certain kind of claim?
Well, Your Honor, to the extent I understand what you're getting at, first, I do think that you really do have to grapple with the aiding and abetting liability issue, and Twitter sets out the framework. But even if you want to take a step back and look at what Congress was getting at more broadly, Congress's entire purpose was to prohibit lawsuits just like this one. It was trying to prohibit lawsuits that had been brought by the city of Chicago, the city of Cincinnati, the city of Boston on theories and seeking relief exactly like this one. So if you adopt my friend's position on the other side, you have essentially gutted PLCAA. And remember what the larger purpose of PLCAA was. It was actually to ultimately protect Second Amendment rights by preventing plaintiffs from bankrupting the industry through frivolous lawsuits. After all, the Second Amendment doesn't really mean anything if there's nobody from whom you can buy a firearm. So I'm willing to take...
just to follow up on this, PLCAA, as you call it, says that you've got to show a violation of a state or federal statute. And Justice Thomas asked you, and I'm still not sure we've completely identified what that statute is. I think it's 18 U.S.C. 922, maybe 923. You agree with that?
Your Honor,
we don't know.
I don't think the complaint was clear on it. We did speculate about that. We speculated about it in our brief. I think that might be the statute.
And then trading and abetting would be 18 U.S.C. Section 2, I think.
I think that's right, yeah.
Okay. All right. I just want to be clear on what is being alleged. And then your friends on the other side make a good point about our precedent in direct sales, which I did not write either and is about 80 years old, too. I want to give you an opportunity to respond to that.
Sure. I will agree with them on one point, that direct sales is their single best case, and direct sales isn't even close. In direct sales, you had a manufacturer that was selling to a specific doctor in such massive quantities that there was no possible lawful explanation. And in addition, the manufacturer then further encouraged that doctor to buy more by offering it massive discounts on bulk purchases. So to use the language of Twitter, you had both a very high degree of scienter and a very high degree of conduct and encouragement. Well, nothing like that here.
That raises another question I had, and then I'll stop. But in terms of aiding and abetting under Section 2 for 922, if that's what we're talking about, those are criminal statutes. And Rosemond says that aiding and abetting in the criminal arena generally requires intent, not knowledge. But you didn't make anything of that.
Well, Your Honor, I think that because they don't come anywhere close on any standard, whether you call it knowledge, whether you call it intent. Remember, in Rosemond, the defendant was actually part of the drug transaction. The question was, did Rosemond, in participating in that drug transaction, also know that one of his collaborators was going to shoot somebody? You don't have anything like that here. The other respect in which this is far different from Twitter, in a way that also highlights direct sales, is that in Twitter, the defendants there were far more active. We were here just a few weeks ago talking about algorithms. The way that algorithms work is that they match up the creator's content with the user's interests. So it starts out with ISIS's vile content. It surveys the billions of users on the platform, figures out which ones are actually interested in that content, and puts the two together. We're not doing anything even like that. This is an a fortiori case after Twitter.
Counsel, the complaint says that 2% of the guns manufactured in the United States find their way into Mexico, and I know you dispute that. But is there a number where your legal analysis might have to be altered? If it's 10%, if it's 20%, at some point the proximate cause lines that you draw really can't bear the weight of the ultimate result.
So, Your Honor, I take their complaint as it comes. If we're talking about proximate cause, I don't think that the percentage would actually matter when you have a multitude of intervening independent crimes. In Hemi, for example, I don't think it would matter whether the city was losing.
And that's the correct answer. It doesn't matter if it's if it's 100%, okay, it might be the only time. It doesn't matter. There are intervening causes that interfere with this. Other people have interfered. There's so many people involved in this chain of events that these manufacturers have no liability. And that's a great answer. It doesn't fucking matter.
Whether everybody was not paying their taxes in New York City or just a small percentage were not paying their taxes in New York City. What mattered is that you had the independent decision of the New York City taxpayers not to pay their taxes that broke that chain. Here you have a multitude of intervening independent crimes. So I don't think that percentage would matter at all on my
Well, I mean,
at
some point it must matter. I mean, I understand you don't want your theory about the different steps, but if it ends up that most of your product or whatever number you want to get to a change in your view ends up there, you've got to know that. And if you know that, do you still have to go through the intricate step by step, or can you just say, this is what they make and pick whatever number you want? 70% of it ends up in Mexico.
I still think you do have to go through that analysis, Your Honor, but even if you disagree with me, I'm willing to accept the allegations in their complaint and the number of 2% and to be quite confident that that is not enough for proximate cause, particularly when their theory is that simply because a firearm was found in Mexico at a crime scene and can ultimately be traced back to a particular retailer that sold it in the first instance, that means that the retailer illegally sold it and that we knew the retailer illegally sold it. Even the ATF and the federal government rejects that theory.
Thank you. Justice Thomas?
Mr. Francisco, in direct sales, there was exactly that, a direct sale to a doctor.
Now, chat, the reason why you're like, wow, Roberts and them are going hard on this, they're making sure they can point out the arguments and show why Kagan, Sotomayor, and Jackson are going to be retarded. That's why they're doing this. That's the reason why they're doing this.
And the seller worked closely with the doctor to work around the limitations. In your brief, you summarized the chain that you've mentioned or alluded to a number of times. Would you just list the chain for our benefit?
Sure. Starts out with a licensed manufacturer, a manufacturer that the federal government says is allowed to make firearms. It then distributes its legal firearms to licensed distributors who the federal government says are allowed to distribute them. They then sell to licensed retailers that the federal government says are allowed to retail. Those retailers, some very small percentage of them, unknown number, but some small percentage of them, transfer those firearms illegally to straw purchasers. The straw purchaser then hands it over to the actual purchaser. You then have a smuggle across an international border, yet another violation of law. The smuggler then presumably gives it to the cartels who are illegally possessing the firearm in Mexico under Mexican law, as my friends have described it. Then the Mexican cartels engage in murder and mayhem against the good people of Mexico, all of which in turn causes the Mexican government to have to spend money to respond to that murder and mayhem. With respect, there's not a single case in history that comes close to that. They don't even cite cases that find a manufacturer, I think, ever liable for the unlawful criminal misuse of its products, other than the cases that PLCAA was meant to prohibit, and perhaps other than the Avis case, the Florida Supreme Court case. But they certainly don't cite anything that comes close to that chain of causation, which is more extreme than the cases that PLCAA was meant to prohibit.
Justice Alito? Justice Sotomayor? Justice Kagan?
So suppose, Mr. Francisco, and this is not the complaint in this case, so I'm making changes to it. Suppose there's a manufacturer and it deals directly with a network of dealers, or there's a wholesaler and it deals directly with a number of dealers. I think one of the defendants in this case is a wholesaler. Either way, let's assume you have a manufacturer / wholesaler that deals directly with a network of dealers. And suppose that that manufacturer does have knowledge that a particular dealer does more than the usual share of straw transactions, and also knows that more than.
So now she's saying things that there's no way they'd fucking know the answers to. Yes, if they knew they were bad guys, okay, great. We're not there, Sonia. This is the problem with the bullshit they do. This is the problem with their bullshit.
The usual share of guns wind up in Mexico, and particularly at Mexican crime scenes. So that the manufacturer, in the way that manufacturers do, I think, when they're dealing with dealer network.
Suffer. No. Nice try, though. Suffer.
They're paying attention to their dealers, and they're trying to figure out whether there's a dealer whose sales are kind of out of kilter with the rest. And they think, yes, I have a dealer whose sales are out of kilter. They're doing more straw transactions. They keep on selling to people who are taking the guns to Mexico, and particularly to people who are leaving the guns at Mexican crime scenes. Is that enough?
Your Honor, that's obviously very different, as you acknowledged. Even in that case, if the manufacturer was simply treating all of the dealers the same, including that dealer, then I don't think you would have crossed the line into aiding and abetting
Treating them the
liability.
same. What does that mean?
So, like say they have a policy that says, look, I sell firearms. Any dealer that wants to purchase my firearms,
I see.
I'm going to sell them to
Okay,
that
well, they
dealer.
are treating them the same. I mean, from one perspective, that's the problem, that they're treating this rogue dealer the same as the good dealers, right? Even though that they know that the rogue dealer is in fact a rogue dealer. Isn't that enough of a problem to bring you in? And where one thing that's not, that is the same, is that we're at a 12B6 stage.
Sure. And Your Honor, I think I'd invoke Twitter, where the social media platforms knew to a meta.
And chat, the 12B6 stage is important because remember, when you're at the 12B6 stage, you filed a motion to dismiss saying there is no relief that can be granted based on the facts, saying everything is true. They do not state a claim upon which relief can be granted. Now, the problem is, and why Sonia Sotomayor is getting to that, is she's trying to say, well, we haven't even gotten to discovery. There's no information. We just have a complaint. And this is her way of trying to say, well, maybe we need to flesh out discovery some before we dismiss. And that's something the court will do at times. And that's one of the things they have to consider. But I don't think in this case it will. I think it's pretty much straight on. But, that's what she's trying to get at.
Metaphysical certainty that ISIS was on its platform doing nefarious things. And that knowledge to a metaphysical certainty wasn't enough if you were simply treating your customers all the same and you were indifferent to what they were doing. I think this case is a lot easier than Twitter.
Yeah, I guess that's the
respects.
question. Is the case that I gave you, is it a Twitter or is it a direct sales? It seems to me more like a direct sales. I'm a manufacturer. I have a dealer network. I know that there's one dealer that's way off the beaten track and doing things that are really different.
Right.
That seems a direct sales.
And if I can explain why I think that direct sales is far more extreme than your hypothetical. Remember, in direct sales, it wasn't just that this doctor was purchasing so much that there was no possible explanation. There was no issue. Nobody even argued about whether the direct sales was treating everybody the same. But in addition, what that manufacturer was doing was explicitly encouraging that doctor, who it was knew was already illegally prescribing, to do it even more. There's an example in the facts, for example, where the doctor orders 2 batches of pills, one for 1,000 pills and another for 100 pills. And direct sales comes back and says, don't do that. I'm just going to cancel your 100 order because I'll sell you another 1,000 pills at this massive discount. So you not only had a high degree of knowledge, you had a very high degree of conduct with the manufacturer actually encouraging.
So you think that's
oversale.
necessary to direct sales, that there's a kind of encouragement in addition to a realization that your products are being used in this way for these purposes?
Yeah, I think that's the necessarily implication of Twitter, where you had knowledge to a metaphysical certainty that one of your customers was doing something bad. But what the opinion makes clear is that simple knowledge doesn't get you across the line unless you're, in addition, acting in an unusual ways.
How about if the conduct is like, and we do this for everybody, don't get me wrong, we do this for everybody, but it's particularly maybe important to Mexican gang members, is that we make it so that you can, easily scrape off serial numbers. And we construct a set of products that are obviously useful in their characteristics for cartel members.
Well, Your Honor, the more you ratchet up the facts and make them cartel specific, I think the closer you do get
because
to direct sales.
Those allegations are in this complaint, right? That the manufacturers have basically designed and manufactured a set of weapons with a set of characteristics that are peculiarly useful for criminal activity.
Well, and that's where I don't think you would be getting anywhere close. If we simply make our firearms in a way that the general public likes, and we allow whoever wants to buy our firearms, and we know, as in Twitter, that some percentage of them are going to do something wrong. That's not the type of affirmative action that gives rise to aiding and abetting liability. After all, the social media platforms and Twitter did know that ISIS was on their platform. They were much more active than we are in the ways that I've already described. This court said as a matter of law on a motion to dismiss that that wasn't even close enough because there was no unusual treatment of ISIS relative to any other customer.
Thank you.
And there was no affirmative conduct towards ISIS.
Justice Gorsuch.
Just one question. Is there any reason for us to reach the proximate cause question if we conclude for aiding and abetting that you win?
If you rule for us on aiding and abetting, that will completely dispose of the case. The reason to also address proximate cause is because it's an extraordinarily important issue that I think applies in many different contexts, which is why there's such a broad range of amici in this case that go well beyond the firearms industry. So while you could completely resolve it on aiding and abetting, I would urge you to address proximate cause as well.
Justice Jackson.
So, Mr. Francisco, I'm just trying to understand what you mean by resolve it on aiding and abetting liability. Don't we have to have a conception of aiding and abetting liability that is specific to this statute? You seem to be drawing on others, and I thought we took a statute by statute approach to aiding and abetting liability. We've held as much. We've said that before.
Well, Your Honor, in Twitter, you were applying aiding and abetting principles that arose in the context of a murder. When you were talking about social media platforms. I think the whole point of Twitter was that there is a set of general aiding and abetting principles, and that is the law that informs what aiding and abetting.
But
I don't even know how you would do this kind of statute-specific aiding and abetting liability outside of the general principles.
Well, I thought we were only looking at aiding and abetting to the extent that Congress mentions that in an example in the statute. So what we're really doing is trying to understand what Congress intended with respect to the exception that it put in this statute. And so to the extent that it references aiding and abetting liability in one of the examples, that is just to...
She is a complete retard. She is a complete retard. Oh my God. She is so retarded. I just don't understand it. I just don't understand it.
illuminate the meaning of the statutory terms that exist there, right? I mean, it's sort of odd to me that suddenly a common law of aiding and abetting liability is coming in to, in your view, be dispositive of how we think about this case.
Sure. Well, I think that it's an example that the reference to aiding and abetting in the statute is an example of a violation that then triggers the statutory exception and the proximate cause analysis. So you have to understand then what it means to aid and abet a particular crime. Again,
as Congress intended it for the purpose of this statute.
Well, and I think it's not that plausible to say that Congress had some completely idiosyncratic view of what aiding and abetting was for the statute, as opposed to just looking to the principles like this court looked to in Twitter, which are just the basic aiding and abetting.
Can I just ask you about your proximate, can I ask you about the proximate cause? Because I'm still a little confused about where you start your proximate cause analysis. I listened as you discussed with Justice Thomas the steps, the series of steps from your clients to the alleged ultimate harm. But it seemed to me that the first moment of illegality in the chain, that, as you articulated it, was the retailers selling to the straw purchasers. Am I right about that? You say your clients do things that are legal. They sell to other legal buyers and et cetera, until we get to that straw purchaser point, right?
That is the first moment of illegality, but I don't think that's the sole step relevant to a general proximate cause analysis.
Right, but we don't have a general proximate cause analysis. We have a statute, and the statute makes clear that we're starting with an action in which a manufacturer or seller of a qualified product knowingly violated a state or federal statute applicable to the sale or marketing of the product. So it seems to me that the first step, given this statute, is the moment of violation, of illegality, as opposed to some theoretical original point.
And my answer to that question is no, but it doesn't matter.
No, I understand you think you make it anyway, but I'm just trying to understand why you're insisting that it's way back here.
Because what the statute says is there has to be a proximate cause between the defendant's violation. Our violation is not the illegal sale itself. We don't sell to consumers.
But you say you don't violate at the beginning, so I don't know what your violation is unless it's the point of illegality.
It's the aiding and abetting. That is the whole aiding and abetting theory.
Thank you.
Thank you, counsel.
Thank you, Your Honor.
Ms. Stetson?
Now,
Mr. Chief
Chat-
Justice, and may it please the court. Mexico.
Now, chat, here's the thing. Like, that's how retarded the argument is. Even she couldn't make it work. He's like, it's not our aiding. Like, we're not doing this. We didn't come up with this theory. They did. Like, that's how dog shit this theory of liability is right now. And that's the problem with it. It doesn't fucking work. It literally does not work, guys. That is the entire problem with this theory of the case they're presenting. It doesn't fucking work. Now, here comes the Mexican government. They're going to get fucking BTFO'd. I haven't even heard this, but I know it's coming. There's at least 5 of them who are going to fucking light her up. He's going to kill her. He's going to kill her. He's going to kill her. And he's going to kill her. Like, those 4 are just going to straight up kill her. He's going to help, and she'll probably watch. So, you got 6 of them who are about to kill her right now. Here we go.
Mexico's complaint pleads that petitioners aided and abetted violations of specific federal gun laws, and that those violations proximately caused Mexico's harm. That satisfies PLCAA's predicate exception. First, the complaint details that petitioners deliberately supply the illegal Mexican market by selling guns through the small number of dealers that they know sell a large number of crime guns and who repeatedly sell in bulk to the cartel traffickers. Petitioners' arguments ignore these allegations. Next, as the court said in Twitter, an aider and abetter is liable for harms that were a foreseeable risk of that violation. That framing, foreseeable risk, is the proximate cause question. As this court put it in Bank of America, does the harm alleged have a sufficiently close connection to the conduct the statute prohibits? The answer is yes. The laws broken here are designed to keep guns out of criminals' hands. Those violations put guns in criminals' hands, and those criminals harmed Mexico. Petitioners' arguments would rewrite PLCAA and proximate cause law far beyond this case. Petitioners argue that independent criminal acts sever the causal chain. But an independent act, criminal or not, only breaks the causal chain if it is not foreseeable. These acts were foreseeable. Petitioners argue that Mexico's injury is not direct, but their directness argument borrows from cases involving indirect victims. Mexico is not an indirect victim.
Yeah, they are.
We are here at the beginning of this case. This court need not vouch for Mexico's allegations, but it must assume they are true. And the issue at this stage is not whether every aspect of Mexico's complaint survives, but whether any of it clears the predicate exception. Mexico should be given a chance to prove its case. I welcome the court's questions.
How is your suit different from the types of suits that prompted the passage of PLCAA?
Our suit is different, Justice Thomas, because the types of suits that prompted the passage of PLCAA specifically did not allege that the manufacturers had violated any law. So if you look, for example, at the Third Circuit's decision in City of Philadelphia, the Illinois Supreme Court's decision of City of Chicago, each of them specifically made the point that those manufacturers were not alleged to have violated any federal or state statute. They were being held liable for actions solely caused by criminals. And that's the important balance that this bipartisan act struck. If an action was solely caused by criminals, manufacturers of guns, like any other product, wouldn't be held liable. But
well, it seems as though the only connection or the difference would be the allegation or the assertion that you have an aiding and abetting problem with respect to the manufacturer. You could have done that in the other cases, couldn't you?
I don't know that they could have, and they certainly didn't. And PLCAA, for more to the point, could have also barred, as many states did, all lawsuits against manufacturers. Many states barred lawsuits by cities. Many states barred lawsuits by all manufacturers. PLCAA didn't. And what PLCAA did was to preserve exactly these types of claims. You asked a question about the specific allegations of illegality. I want to direct you to paragraph 249 of the complaint. There is a list at paragraph 249 that includes 18 U.S.C. 922, several different subparts, A6, D1, 923 G1, 924 A1A, and those map closely onto the predicate exception we're talking about, including, of course, that first example of the predicate exception, which involves aiding and abetting a straw purchase, which is at the core of what we are talking about. That's 18 U.S.C. 922A6, 922T1, 922M, 924A1A, 923G1A. Each of those are specified in the complaint, and the manufacturers and distributor in this case are alleged to have aided and abetted all of them.
Counsel, I'm sorry.
Just one last. Have any of these violations been violations that ATF has pinpointed?
They have not been violations that ATF has pinpointed, and that's a point that the petitioners are fond of making. I think the issue with ATF, as the complaint alleges, is that ATF, and you can find this at paragraphs 126, 129, 133, ATF, just because of its resources, is only able to look, even every year, at about anywhere between 3 and 10% of licensed dealers and manufacturers and distributors. And if PLCAA, again, had wanted ATF to be the sole arbiter of this, it could have barred cases altogether. It could have required a conviction. It could have required the stripping of a license before any of these
They didn't anticipate fucking idiots like you.
Allegations were allowed to go forward. It didn't do any of those things in the predicate exception.
Counsel, in his argument this morning and also in his brief, Mr. Francisco focused on two particular cases, the Twitter case, of course, and you engaged with that in your brief, but also Hemi Group, and you cite that once in a string cite at page 42 of your brief. I wanted to give you an opportunity to say a little bit more about that.
Certainly. So Hemi Group, of course, pertains to the proximate cause issue. And Hemi Group, I think, is in a line with all of the cases that talk about what my friend Mr. Francisco calls direct harm. And that's something that you heard a lot in his argument. Direct came up a lot. Independent came up 13 times. Direct harm, if you look at Hemi Group, if you look at Associated General Contractors, Holmes, ANZA, Bridge, there is a list of proximate cause cases. And if you look at each of them, what you will find is that the issue there was that the victim who was bringing the complaint was an indirect victim. So this court, like many of us, finds it hard to speak with one voice on proximate cause. One of the few times it has is in Lexmark. And what Lexmark says is the reason for that directness requirement is that there ordinarily is a discontinuity between the injury to the direct victim and the injury to the indirect victim, so that the latter is not surely attributable to the former. That, I think, is an important component of the proximate cause argument. And I want to touch on this independent idea because it came up so much. As I said in the opening, an act that is independent can still be foreseeable. It's when an independent act is unforeseeable that you have the intervening cause that breaks the causal chain. So Mr. Francisco mentioned that 1876 case that Justice Gorsuch did not write about Milwaukee Railroad. That is the case that says the primary cause may be the proximate cause of a disaster, though it may operate through successive instruments as an article at the end of a chain may be moved by a force applied to the other end. So it's not a question about one step or a causal chain. It's a question about whether something breaks that chain. Hemi was an example of something breaking the chain because you had unlawful contact over here and an injury over there, and the two weren't connected by anything other than a very articulate series of steps. The injury and the conduct were very different.
It's nearly impossible to say that something's not foreseeable in a chain. It doesn't help me when people talk foreseeability. I'm much more helped by the restatement third of torts that basically says
And chat, the restatement of torts is kind of like, remember how I mentioned this? There's the restatement of contracts, the restatement of various other issues. And that's kind of like a compendium of information that's broken down by judges, professors, lawyers, law professors, that kind of states out basic general thoughts and theory for, in this case, torts. So any kind of tort law, and that's why it's called a restatement of it.
impose liability
And there's nothing wrong with relying on that, because that's kind of like the beginning steps of understanding shit.
for harms within the scope of the risks that made the defendant's conduct wrongful in the first place. That makes much more sense because, as I started earlier with Mr. Francisco, we know that a straw seller is going to sell to someone who is going to use the gun illegally, because if they weren't, they wouldn't use the straw purchaser. And that illegal conduct is going to cause harm, and harm like this, that the gun is going to be used in some way to injure people. Correct?
That's correct.
And that basically is much easier than saying that all foreseeable harms are, you're responsible for all foreseeable harms. You're only responsible for those that your wrongful conduct causes a risk about.
That's exactly right, Justice Sotomayor, and that's why I started with that reference to Twitter, because when Twitter talks about the aider and abetter being responsible for harms that are a foreseeable risk of the conduct, that's the closest thing that I've seen that comes to encapsulating what a proximate cause test is. It's foreseeable
Now, can I go
risk.
back to what's troubling me? You have the manufacturers aiding and abetting, in your theory, by producing guns that are singularly attractive to the cartel because they're designed in a particular way that cartel members like because they're showy. They're making erasable serial numbers, which obviously are attractive to criminals because every criminal would like to erase the serial number if they can. So that's what you claim is aiding and abetting. But what are you claiming Interstate, the distributor wholesaler, did? Other than selling the product, they don't design it. They didn't do any of the, they didn't design it. They didn't have anything to do with that. They just have a product they're selling. So how do we make, how are your allegations enough with respect to Interstate? And if we were to say they're not enough with respect to Interstate, doesn't that break the causal connection with the manufacturers?
Justice Sotomayor, the complaint actually details 6 or 7 different examples of how the manufacturers are actively participating in the illegal market.
I'm
one of them
accepting
is
that.
design. Yes, yes.
I'm asking, tell me what it says that the distributors are doing.
What it says the distributors are doing, including the one that's named in this complaint, are knowingly supplying the dealers who we know sell unlawfully across the
But
border.
knowledge is not enough. We have repeatedly said mere knowledge is not enough. You have to aid and abet in some way. You have to intend and take affirmative action to encourage what they're, not to encourage, but to participate in what they're doing.
What this court said in Rosemond is a person who actively participates in a criminal scheme, knowing its intent and character, intends that scheme's commission. That's the criminal aiding and abetting standard.
Yeah, that is the standard. That was a question I wanted to circle back with you on, Ms. Stetson. And that if 922 and 3 and 4 are your predicate violations, and aiding and abetting under 18 U.S.C. Section 2, I think, would then be your aiding and abetting hook. Those are criminal statutes, and the mens rea under Rosemond is intent, right?
The mens rea under Rosemond for aiding and abetting in the criminal context would be intent.
And you're invoking criminal statutes, so is that the standard you have to meet here?
It's the standard we have to meet. But just as in Rosemond, if you actively participate knowing the scheme,
Sure, then you can infer
then
knowledge.
you can infer
I
intent,
get that.
particularly at the motion to dismiss stage.
Yeah, got it.
And let me, if I could, I want to be pretty specific about some of the allegations in the complaint, because what I heard this morning was that the allegations are vague and so forth. I want to point you to a few particular allegations.
They're absolute garbage.
Two of them are at paragraphs 122 and 146, and this has to do with trace data.
Yes, it would be.
Defendants are alleged to regularly receive, I'm sorry? Paragraphs 122 and 146.
Yes, chat. I mean, this is not going very well. They are taking a beating here, and it's not going very well. Gorsuch is savaging them very, very well going through this. But, like, everybody is taking a bite out of her ass. You know, and she says, like, here, you've got to aid it and bet specifically. And they haven't done that. Like, Sotomayor is really fucking making them hurt.
I'm starting with. Regularly receive even more direct information about problem dealers. Trace requests from ATF and other agencies alert defendants that guns they sell to specific distributors and dealers are being recovered at crime scenes. Paragraph 146. Authorities have repeatedly identified and recovered defendants' guns in connection with notorious gun trafficking rings. Paragraph 232, defendants are aware that specific networks of distributors and dealers they were supplying were consistently channeling their guns. Paragraph 233, Century Arms received communications from ATF. Those trace requests revealed that specific distributor and dealer networks were disproportionately associated with those guns. Paragraph 234, all of the other defendants have access to the same information. That is exactly the kind of specific allegation in the complaint at this stage that satisfies a motion to dismiss.
But those statements aren't allegations of violations of the law, correct? I mean, those statements just go to whether or not the defendant had knowledge that at the end of the day, some dealers might be doing something wrong. These guns that they're selling are ending up in the wrong hands. But I took the statutory language here to be requiring more in terms of violation on the part of the defendants in this case.
It certainly requires, Justice Jackson, a knowing violation. But as far as these allegations go,
guys, when Ketanji Brown Jackson is fucking saying I can't go with this, and she is casting doubt on what's going to happen here. Uh-oh. I mean, really, even Ketanji Brown Jackson's like, yeah, I'm not really so sure about this. Yes, Century Arms is a massive importer and seller. Yeah, yes, Ketanji Brown Jackson actually made sense. Yeah, this is going to be like 9-0 probably. Do they articulate why they aren't going after the specific distributors? Well, there is one or two distributors involved, Century, but most of it is them going after the gun companies because that's where the money's at. So they're admitting that Smith & Wesson is at least 3 degrees removed. Yes. Yep. Mm-hmm. Is this a Soros-backed lawsuit? No, the Giffords campaign's involved, though. So, yeah, I guess George Soros is involved.
what these allegations show is that the dealers, a small number that is responsible for the large number of guns, are knowingly violating federal laws, and that these suppliers, these manufacturers and the distributor know that is happening and continue to actively supply. And I want to
What you don't have is particular dealers, right? I mean, it's a pretty, there are lots of dealers, and you're just saying they know that some of them do. But which some of them? I mean, who are they aiding and abetting in this complaint?
There are a number of dealers that we do know are responsible for selling a great number of crime guns into Mexico. There's the Washington Post article that the complaint mentions. That names 8 or 10 different dealers by name, most of which are still very actively in the business. And more to the point, again, we are.
Even Kagan now is like, oh no, chat. Oh no, anti-gun bros. Oh no, Mexico bros. I don't feel so good.
Here at a motion to dismiss, what we have alleged is that these manufacturers know from ATF exactly what dealers are the problem, are the rogue dealers. So the hypothetical that you gave Mr. Francisco, Justice Kagan, is not a hypothetical. That is actually this case. The allegations in this case establish, for purposes of getting past the motion to dismiss on the predicate exception, as Justice Jackson mentioned, that there are allegations of aiding and abetting, violations of federal laws. And I want to get back to a question that Justice Barrett asked as well about what the violation is, because I think there's been some noise in the data.
Ms. Stetson, before you do that, could I just ask you?
So, okay, so Yin Yang, this does, like, they do highlight the justices when they speak, like right now Alito's speaking. That woman that was speaking was arguing for Mexico. So that's why nothing was lit up while she was talking. Yes, Estados Unidos, Mexico felted. Ba 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 ba. Yes, this is bad. This is bad. This is not going well.
Something related to the point you were just discussing. Are there any allegations in the complaint that the petitioners knowingly sell to specific red flag dealers?
Yes. If you look at paragraph 247, and I'll read it because I think this one is important. Defendants supply dealers with all the guns they can pay for, without any public safety conditions, even if a gun dealer has been repeatedly found to have violated gun laws, been indicted, its employees have had federal gun licenses revoked, or has repeatedly supplied cartels in suspicious and obvious sales to traffickers, including repeated bulk sales. That is an allegation that goes directly to specific rogue dealers. And that gets us, I think, to the Twitter direct sales dichotomy. What Mr. Francisco says is that Twitter was very actively managing something. Twitter was actively managing, to the extent it was managing anything at all, its algorithm. And what this court said in Twitter was that that kind of starting the platform, sending it out into the world, and standing back and watching, which was the phrase in Twitter, is not enough. What you need is active, culpable participation. The active, culpable participation here is continuing to sell guns to rogue dealers that you know are the problem dealers.
That is exactly identified the dealers. Justice Alito is asking you about specific red flag dealers, but that paragraph doesn't identify dealers, and it seems to me that that's one of the distinctions between this case and direct sales, and for that matter, this case and Twitter. Let's talk about Twitter. There was a specific rogue actor, ISIS, and there was a specific attack in France. And so the attempt was to draw the line between them, and we said it wasn't enough. In direct sales, there was a specific manufacturer, pharmaceutical company selling to a specific doctor, causing specific harm. And Justice Alito asked you what specific red flag dealers there are. You haven't sued any of the retailers that were the most proximate cause of the harm. You haven't identified them that I can tell in the complaint.
Justice Barrett, there are many, many paragraphs that specifically identify rogue dealers in the complaint. If you look at approximately paragraphs 147 to 203, they identify specific dealers that have been found to have sold guns in bulk to traffickers that go across the border. If the question is, you haven't named in paragraph 247, which says that these manufacturers know that they're selling to dealers who sell to cartels, I think that is pushing a little bit past what is necessary for drawing reasonable inferences from a motion to dismiss. But I want to pause too on Twitter and direct sales. Direct sales involved an entity that was selling large quantities of morphine to a doctor. The entity was licensed, the doctor was licensed. And if you look at direct sales, what direct sales says is that the quantities that were at issue were in line with that defendant's marketing practices. There was nothing unusual about the quantities at issue there. What was unusual in that case, and what is different in that case, is that the direct sales manufacturer did not know that that specific doctor was a problem. It had been put on notice that there were other doctors who were selling lots of their products to people who shouldn't be getting them. But unlike this case, where these manufacturers and the distributor are alleged to know who the dealers are and what problems they are causing, the manufacturer that was held liable for criminal conspiracy in direct sales didn't know anything about that doctor. All it knew was that the doctor kept sending them legal order forms, and they kept fulfilling the orders. That was direct sales. This case is much like direct sales, if not stronger, for that reason.
What do you do with the suggestion on the other side and in the amicus briefs that your theory of aiding and abetting liability would have destructive effects on the American economy, in the sense that, as you've read in the briefs, lots of sellers and manufacturers of ordinary products know that they're going to be misused by some subset of people. They know that to a certainty, that it's going to be pharmaceuticals, cars, what you can name, lots of products. So that's a real concern, I think, for me, about accepting your theory of aiding and abetting liability. And relatedly, you've referred often to the motion to dismiss, of course, as you're well aware. Getting past that is often the whole thing. So I don't think we can just rely on the motion to dismiss. But the broader point, be interested in your reactions, how we rule for you, but don't cause that problem that is identified with great force in the briefs.
Sure. So let's take Budweiser as an example. As you heard Mr. Francisco say today, if Budweiser had a practice, was alleged to have a practice of selling bulk quantities of Bud Light to...
This is gonna backfire. Here we go. I did hear this clip, chat. This goes really bad because speaking of Bud Light, we got Brewski Brett Kavanaugh. Here we go, chat.
Liquor stores that were arranged next to high schools. And it was selling more and more into those high schools, knowing that those liquor stores were regularly serving underage students. And in fact, the Bud Light designed to put out a new can that says "Best Prom Ever" and sold it right into that high school. That is the allegations in this case. If you have a product manufacturer of a dangerous product that is alleged to have done all of the things knowing who they're selling to and what is being done with that product, then and only then, I think that product manufacturer has a problem. If you look at the examples that are given in PLCAA that aren't at issue in this case, the examples that the congressmen and senators were concerned about in PLCAA were when a car dealer sells a car to someone who later drives drunk, when Campbell's is sued because someone is killed.
Aaron Perez, oh God, I'm going to butcher this. I'm sorry. Milicia. Masua, or Milsua, I'm sorry, Aaron. Aaron. I want people to understand this is not a representation of Mexico. I understand. Your government sucks, but you know the cool thing? I'll let you in on a secret. Our government really sucks too, so our government really sucks as well. It's okay. And yes, I can only imagine how difficult it is to deal with your government who basically enables and probably supports most of this illegal activity going on, and then gets mad at you and attacks you for daring to stop this cartel activity, because that's been documented before. Then when people stand up to the cartels, the Mexican government stops them. So I can only imagine how that feels. So, but no, we understand. There is a difference here. Yes, this is the Mexican government. I'm sure the Mexican people would love to be awash in guns right now and handle their business with the cartels. So. Oh, check Discord. Okay, I will in a second. Yes, imagine mine now. It fucking sucks. Yes, well, yeah, you guys banned like everything. Canada banned like almost all the guns yesterday. Like everything, even like an SVT-40, like a World War II semi-automatic rifle. Everything. So, yeah. So, yeah. So, yeah, it's going there. It's just going there. And yeah, ACB has not identified the dealers and everything that's going on there. She has no answer for what's going on here.
With a soup can. Those are the things that PLCAA was concerned about. This case is marches through in detail allegations taken as true at this stage that these manufacturers know that they are selling a dangerous product to specific rogue dealers who are selling to straw purchasers for the cartels across the country.
What if a beer, I'm sorry, I cut off your sentence. What if a beer manufacturer knows that the per capita beer sales in a small college town are, 50 times more than another town without a college there? Is that enough?
I don't think that alone would be enough. I mean, you do have allegations in this complaint that the number of dealers that have arranged themselves along the border of Texas and Arizona of Mexico are vast. I don't think that itself would be enough. It would be, the dealers are there, what they're selling, who the bad apple dealers are, because we're not talking about every dealer in the country. We are talking about a small percentage of retailers responsible for about 90% of the crime guns that are found. Those retailers in that college town, if you plug in that hypothetical of Budweiser, and Budweiser was marketing in with some kind of, best first year homecoming ever, then you would again have the problem. But you'd have to have each of those specific allegations in the complaint that you have here.
Ms. Stetson, I guess what I'm concerned about, you talked in response to Justice Kavanaugh about what PLCAA was about, what it was getting at, and I really thought, as the statute itself says, that it partially, at least, is about Congress protecting its own prerogative to be the one to regulate this industry. That there were concerns, and the statute itself says that, we're worried that tort suits are an attempt to use the judicial branch to circumvent the legislative branch of government. And to me, when you think about that as being the reason why Congress wanted to have immunity in this area, and I'm starting from I'm sure, consensus view that we're trying to do what the statute wants. I think when you think about that, the predicate exception makes perfect sense to the extent that there's a violation of a state or federal statute at issue. Because Congress says we want to be the ones to regulate, but in this particular situation in which a tort suit aligns with a clear violation of the law, then we don't worry that we have judges and the common law system dictating what people can do. I worry that without that clarity, in a complaint like yours, where we don't really see exactly how the manufacturers are violating a particular state or federal law, that we're running up against the very concerns that motivated this statute to begin with. So can you speak to that?
Sure. Justice Jackson, I think
chat, this is not going well. This is not going, nobody is supporting them. No one's supporting them, and that's got to be rough. That's got to be so rough. Yes, the answer to all this is there's nothing they can do here. There's nothing they can do. So that's the thing here. Sean, are we going to win against these corrupt pieces of shit? Yes. I mean, think about it. You've got all six. Like, you've got the whole conservative wing going along with this. Jackson is probably going to go along with it. Kagan's definitely going along with it. Sotomayor is definitely going along with it. It's 9-0 or 8-1. Like, there's no, yeah. Why did Bama Law? How you doing, buddy? Guys, remember, you can find him over at Bama Law here on YouTube. Not just talking about, the law regarding the state of Alabama, but he does talk about law things, and he is in Alabama. So that is the difference here. So he's not just like, Roll Tide Law. But if you guys want to, hit him up here at Bama_law. Take a look. You guys, I think you'll like it. So we're going to get back to this here. Let's see if they got any other questions. Habla Inglés, yes. But yeah, guys, nobody is backing them up. This is not good at all. Aquila said he should have said Corona and not Budweiser. Tenoch is saying, does this mean I won't buy them a gun and send it to you in Scotland? No. I'm just saying, though, 3/4 inch pipe or, I don't know, what is that, 16, 17 millimeters is about 12 gauge. Something to think about. Something to think about. Something to think about. Shukino. Shuinoko Z says, I'm literally on Century Arms right now. Find my way there looking for K31 accessories. Yes. I'd love to have a K31. Those are so cool looking, but they got fucking retarded. And for a while, I wasn't really big on them because the 7.5 Swiss was hard to get a hold of. But God, I'd love to have one now. I'll look for one at some point, maybe. But anyways, yep, good stuff out there at Century. Well, they're not making dog shit, but yes, normally good.
If you look at the paragraphs, let's call it 203 to 250 of the complaint, which pertain exactly to the violations of federal law that we started with, all of the specific statutory violations, 922 subparts, 923, 924. What you will find is that there are plentiful allegations that these manufacturers, by knowingly selling to the rogue dealers that they know are selling to straw purchasers, are aiding and abetting that violation. Part of the problem
I understand, but I guess my point is that Congress didn't want like general aiding and abetting concern.
Oh my God. Wow. She just comes right into this.
Part of the problem
I understand, but I guess my point is that
like Ketanji Brown Jackson is just like really fucking getting in there. Like, listen to this. She's like, look, yeah. Like, she just comes in there fucking swinging on this lady. Woo, buddy. Oh, buddy. This is not good. Like, you know, there's times where, like we've said, if you're getting conversed with, that's good. If you're not getting talked to at all, that's generally bad. This is also the opposite. When you're getting talked to and literally no one's buying your shit, I've been on this. This is normally what happens at a criminal appeal. They ain't buying your bullshit. They like even Ketanji Brown Jackson's like, fuck all this.
Congress didn't want like general aiding and abetting concerns to be what is imposing duties on these manufacturers. I mean, if you look at your lawsuit and what you're asking for changes to the firearm industry safety practices. You say not, putting these kinds of constraints is a thing that should be give rise to liability. The distribution practices, the marketing, all of the things that you ask for in this lawsuit would amount to different kinds of regulatory constraints that I'm thinking Congress didn't want the courts to be the ones to impose.
So let me answer the aiding and abetting liability point first, and then I want to answer your remedies point because I think that's particularly important. Aiding and abetting, of course, was specifically contemplated in PLCAA in the first predicate exception itself. Any case in which the manufacturer or seller knowingly made a false entry, et cetera, or aided, abetted, or conspired with any person in making any false or fictitious statement. Aiding and abetting is baked into this.
So you don't read that to be very, very closely tied to the record-keeping violation or the particular statutory violation that's also mentioned.
No, I mean that the predicate exception begins by talking about the action in which the manufacturer knowingly violated, and the violation was a proximate cause, including the exceptions that are mentioned. So aiding and abetting these violations of federal and state statutes pertaining to guns is exactly what this exception was built to do. That is why it was carved out in this bipartisan legislation. But on your remedies question, one of the difficulties I think for all of us is that we're here so early. This is a complaint that has asked for a number of different remedies, including a number of different types of injunctive relief. And one of the things that you heard the petitioners and a lot of their amici in their briefs complain about is what these remedies might do. That is for the district judge on remand to make sure that the judge equitably crafts a remedy that is designed to limit the harm to Mexico. Mexico is not trying to legislate gun use in the United States.
Yeah, I understand that. I guess I'm just wondering.
Real quick chat. Wanted to show you guys all. We have a Clyde sighting. Hi, Bubba. Hi, Bubba Bear. Anyways, you guys want a Clyde? I got you some Clyde. Yes, but she admits some of her remedies are bullshit. Yeah. She's having to bite some bullets here, chat. No pun intended. Fatty K says, you ever made an appeal and just said I had to? Yes. Yes, it's all. You also do a thing called an Anders brief saying, I'm filing this appeal and there's literally no reason for it. I can't find a reason. Here's my analysis why there's no reason. But yes, sometimes you just have to go on you have an oral argument because the other side wants one. So it happens. Good to see you, Fatty Catty. Siobhan saying, does she have a chip in her brain too? Hi, Bubba. Hey. Hey. What you look like? Look, Clyde. See, there's nothing here. But look up here, buddy. Look. Look up. Yeah. This screams the cartels asked Mexico to take guns so they can run everything. Yeah. Yeah. It's not just me. I hear the chirp when she starts talking. You guys are...
Whether the PLCAA statute itself is telling us that we don't want the courts to be the ones to be crafting remedies that amount to regulation on this industry. That was really the point of the entire thing. And so to the extent that we're now reading an exception to allow the very thing that the statute seems to preclude, I'm concerned about that.
Justice Jackson, if PLCAA had wanted to preclude any lawsuit against a manufacturer, including for instances where the manufacturer had committed a wrong, it could have done that, as so many different states, in fact, did. What PLCAA did in this effort, which, as I mentioned, was joined by members of both parties, was to carefully carve out circumstances where the manufacturer or the seller was alleged to have done something wrong. The thing they were concerned about was lawful design and manufacture and sale of product and injuries solely caused by others. That is replete throughout the purpose section of PLCAA. PLCAA could have been designed quite differently.
PLCAA.
It was designed this way for a reason, so that harmful actions by manufacturers and sellers breaking the law could continue to be remedied. That was exactly the point.
You've mentioned about 4 times that it was bipartisan. What's the relevance of that to our interpretation?
I think yeah.
That's, oh my God. He's like, what the fuck does that have to do with anything? She's just trying. He's like, that has no relevance here. And she's like, uh-oh.
So I haven't gotten to 13 times yet, but 4 will do. The fact that it's bipartisan, I think, points out, particularly in this climate, that what was being challenged there were really unusual lawsuits that really weren't showing up in any other part of the economy against the manufacturers of a lawful product, selling their product lawfully, distributing their product lawfully, where no allegations were made in those prior lawsuits about unlawful behavior. That was what PLCAA carefully carved out. What it left, among other things, were actions for things like negligent entrustment, product liability. And product liability is interesting, by the way, because you probably notice this as well. Product liability specifically says you can sue for product liability, but if it was a criminal act, then that act becomes the sole proximate cause. That, of course, is very different from the violation of which is or a proximate cause, which is what you see in the predicate exception. I think that language difference is very important.
Thank you, counsel. I'd like to ask you pretty much the flip side of the question I asked your friend on the other side, which you allege that 2% of the guns manufactured in the United States make their way to Mexico. I assume the volume of that is critical to your argument. I just want to know how much is enough. If it's 1% or a more minuscule amount, where's the floor?
So 2% is always a question that begs the question of what? And here, what you have is data in the complaint that says, this is paragraph 438, between 342,000 and 597,000 of defendants' guns. And remember, this is not the entire industry we're here talking about. So up to 600,000 of defendants' guns are likely trafficked into Mexico every year. That's your 2%. But I think the issue is not so much whether it's 2 or 10 or 70. It's, do these manufacturers know who the rogue dealers are and what they're doing? And this complaint, in all of those paragraphs that I read to you earlier and many others around them, specifically says these manufacturers know the trace data that show the dealers, that show the bulk sales that are being made to traffickers who come in repeatedly over a short period of time and bring the guns into Mexico where they're found at crime scenes. That, I think, more than percentage is important.
You emphasize you have a number of criteria or examples. You know, the gun says this, or it looks like a military weapon and it has an American flag. And, you know, Zapata's quote about better to die on your feet than live on your knees. I mean, those are all things that are not illegal in any way. And the idea, I mean, there's some people who want the experience of shooting a particular type of gun because.
I mean, yeah, he's bringing up that, like, yeah, this is all just bullshit and tampon wrangling. We talked about this at the time, chat, reading through what was going on. This is just watered down, reheated anti-gun arguments that they're trying to do again. That's what's going on here. Hi, Bubba. What's wrong? Come, hey, Clyde, come here. Come here, Bubba. I got you, buddy. He wasn't sitting right. Yeah, this is all just watered down arguments they've tried forever, and they're just retrying again. You know, now they're crying about how it looks.
They find it more enjoyable than using a BB gun. And I just wonder exactly what the defendant, the manufacturer, is supposed to do in that situation. You say, no, he shouldn't be marketing a particular legal firearm because they're going to go into Mexico at a higher percentage than others?
Mr. Chief Justice, I think it's not so much that the defendants are designing a particular gun. It's that what the complaint alleges is that they are designing certain guns to target the Mexican market, including the cartels. So if you take the example that you gave, this is paragraph 215. Colt produces 3 models of guns that it specifically targets to the Mexican market: the Super El Jefe, the Super El Grito, and the Emiliano Zapata 1911. These are coveted by the cartels, and you can see evidence of this as paragraphs 217, 218, 219, 220.
I mean, I'm not going to lie. The Super El Jefe sounds fucking based. The Super El Jefe. I would do that. I would use that. I would use a Super El Jefe. Is that in fucking 38 Super or something? Hold on. Super El Jefe pistol. Let's see here. The Super Jefe. Yes, it's in 38 Super, chat. Why is 38 Super important? 38 Super is because it is a non-military caliber. 38 Super is, you know, a souped-up 38 round and 9mm round. That gives you a lot of performance because in Central America and South America, you can't own a military caliber. So no 9mm, no 357, you know, 38s, no 45s, no 40, no 10mm. So guess what? 38 Super was invented for that purpose. So it's 100% 38 Super. Yeah, I had to Google it. Yes, 38 Super is a sporting caliber. Yes, it is. It is not NATO. Yes, it's not a standard military caliber. So that's why you can own one.
And they are smuggled into Mexico in volume, which you can also find.
Do you know what the percentage of those guns that are sold in the United States compared to the ones that are found in Mexico is?
I don't know, but again, the percentage I think is less important than the allegation that they are smuggled into Mexico in volume and coveted.
I mean, that's the other thing, though, Chad, too. It's now a non-military firearm they're complaining about. But also, there's a large Hispanic populations in the United States who like their guns. Like, you know, the 1911 style handgun and pattern is something cartel members do like. And the traditional in the Southwest, it's still big. But also, 38 Super has a cult following in America. American shooters like 1911's and 38 Super. I've shot a couple before. It's a very nice shooting handgun in 38 Super. It's actually really fucking cool.
By the cartels, including being found on the person of many cartel chiefs who have been arrested.
Oh, yeah.
If there's no earlier finding of a violation, how is that done within the context of a civil suit like this?
If there's no earlier finding of a violation, because of course as I think you're getting at, the predicate exception doesn't require one. There's another exception that does. I think what you would find are that at the motion to dismiss stage, the question is simply, has there been a sufficient allegation of aiding and abetting in order to get you past the predicate exception? Now, we talked about how we are here early. There are actually still other motions to dismiss to be addressed.
But it has to be aiding and abetting of something.
Aiding and abetting the violations, including of straw purchasing.
So it is the violation that you say in your complaint there is a violation, but there's been no finding of a violation. How do we know there is a violation?
I think what the district court would determine at summary judgment, if the evidence comes back and says, for example, these manufacturers simply had no idea what their distributors were doing or who their guns were going to, or these dealers were doing everything by the book and they are not responsible for the straw purchases that kept coming into their stores. If you had that evidence, then on summary judgment, as has happened before, the court would say, we can't find the predicate exception met here.
So let's say I am the alleged straw purchaser or the retailer who sells to a straw purchaser. Now you have found that I have violated the Gun Control Act, right? And my point is, how do you make that finding within the context of this suit?
Justice Thomas, within the context of that suit, I think you would take discovery from the dealer and ask the question, because remember the predicate exception goes to knowing violation. Ask the dealer what it knew when it sold, for example, as has been alleged in the complaint, dozens of guns over a 2-month period to the same person. The evidence at summary judgment will flush out some of these questions. But
so you're saying you can find a violation of selling to a straw purchaser within the context of a civil suit against the wholesalers and the manufacturers?
I think maybe where you and I are parting is on the issue of finding a violation. Yeah. We've alleged those violations specifically in the complaint. As far as finding the violation, I think what the district court would do on remand after discovery, if provided we get past the other motions to dismiss that are pending, after discovery would be to ask the question, has the evidence pointed to actual violations? So if you take the Arcadia, California case, that was a case in which at the summary judgment stage, some defendants were dismissed because there was not evidence that they were acting unlawfully. Others were kept in because there was evidence that they were acting unlawfully. So that might be the best example of the dichotomy you're talking about.
Wouldn't you run into, at some point, a due process?
Guys, we got to stop the fight. This woman is getting murdered. And Clarence Thomas, look at him. He's just got his smirk on. He's pulling his big old dick out. He's hollowing this woman out. He's hollowing this woman out in front of the entire Supreme Court.
Process problem as far as the people you allege to have violated the Gun Control Act, who have not been charged with that by ATF and proven to have done that by the government?
No, I don't think you run into a due process problem, precisely for the reason I think you pointed out a couple minutes ago, Justice Thomas. There's no requirement of a conviction, and there are plenty of examples, including Williams versus B. Miller from New York, of instances where manufacturers have been alleged to have to have aided and abetted a violation by a dealer, and that case has been allowed to go forward. There's not a due process issue that adheres in that.
Justice Alito? There are some very interesting technical legal issues in this case, proximate cause, aiding and abetting, how much do you have to plead in a complaint, and you and Mr. Francisco have briefed and argued those very well. It's very helpful to the court. I just thought I would ask you a question that may be on the minds of ordinary Americans who hear this argument or learn about the case. Mexico says that U.S. gun manufacturers are contributing to illegal conduct in Mexico. there are Americans who think that Mexican government
Yes,
officials
they're
are
their old
contributing
picture.
to a lot of illegal conduct here. So suppose that one of the 50 states sued the government of Mexico for aiding and abetting illegal conduct within the state's borders that causes the state to incur law enforcement costs, public welfare costs, other costs. Would your client be willing to litigate that case in the courts of the United States?
Justice.
Also, Jim Satala. Jim Satala, here you go. Here's your argument. Jim tells you were wondering about this, and I told you to. There's a lot of issues suing foreign governments, but here you go. Here you go.
Alito, I think we would have to accessorize that hypothetical with what I assume are a lot of the things that are built into it, that there are no forum and venue questions, and that the kinds of allegations are specific and talk about.
And this is the kill shot right here. This is Samuel Alito Jr. coming in and kill shotting her. This is the kill shot, chat. This is it. She maneuvered and maneuvered and maneuvered, and she was jinking and banking and throwing chaff, and she's all out of altitude and all out of airspeed, and there's still a Sam in the air chasing her down. There's nowhere to go.
Specific harms to the states.
Well, would your government say, whoa, your client say, whoa, sovereign immunity, you can't sue us on this?
Well,
or would you be willing to litigate all the doctrines that would apply if the government of Mexico were not entitled to sovereign immunity?
So, Justice Alito, under FISA, of course, Mexico is entitled to come in, and the petitioner's own amici point this out, to come into this case just like any other litigant. There are, of course, differences if Mexico is brought in as a defendant. So I can't and certainly don't feel comfortable giving away things like sovereign immunity on behalf of the government of Mexico.
Well, I understand that. So the argument basically is it's a one-way street.
No, Justice
Government
Alito,
of Mexico can.
Clyde Bear, I gotta set you down, Bubby. We gotta get back to work, okay? Guys, say goodbye to Clyde, and maybe he'll come back for the model stream later, but we're gonna have to set you down, buddy, okay? Okay. He's like, no, fat man, I enjoy it up here. So tell him goodbye, Clyde. Goodbye, everybody. All right, buddy, I'm gonna set you on the ground. Okay? There you go. All right. But there you go, chat. If you wanted to see a kill shot, she's literally boxed in. She's boxed in with nowhere to go. There is nowhere to go right here. This is utterly, utterly felted. She has nowhere to go. This is a monster kill. Godlike! I need to save those. I need to get those things to play in here too, but yeah. Oh, real quick, we're gonna address these real quick just because they were big things here. Assholes react. You know, it's like an asshole just quivering up, just you know, I assume it's reacting in a way where it's loosening and not clenching, but maybe. For 20 memberships and another 20 for a total of 40 memberships, just coming in here off the top rope, straightening out you bitches out there that are gray. That's what they're doing. Just coming in. If you gray, he's getting ready to smoke you. He's getting ready to come after you.
Was this story based? Yes.
Very based, mega based. Whiskey 77 and Trey. Uno, dos, tres beers. Coming in tomorrow, every Sunday night at 9 p.m. Guys, so give them a shout, give them a look. Thank you very much for being here. Thank you for the support and your generosity. All right, guys. See, we're almost done, chat. We're in the home stretch here. Yes, Trey's beers. Yes. The top G rope. Yes. Yes, this woman's getting gaped right now, and there's nowhere to go.
Sue U.S. manufacturers here for harm caused in Mexico. But one of the states here can't sue the government of Mexico for harm caused in the United States.
I don't think it's entirely accurate to call it a one-way street. And if the street is one way, it's because Pfizer and other decisions from this court have said that when a sovereign comes into this court as a plaintiff, it is treated exactly like any other plaintiff, no more and no less.
Thank you.
Thank you. Justice Sotomayor? Justice Kagan? Justice Kavanaugh?
Just want to pick up briefly on questions Justice Thomas was asking. I mean, would your theory of aiding and abetting suggest that manufacturers should be concerned if their products, their lawful products, are sold in certain communities or certain neighborhoods where they're more likely to be misused? You know, we manufacture knives, but there are a lot of stabbings in certain neighborhoods. We should make sure our products aren't sold there, or a sporting goods company and baseball bats are used to, you know, storm CVS's or what have you. So we shouldn't sell in this city, or prescription drugs are misused in a certain area. So we need to be alert and make sure. Is that where your theory of aiding and abetting leads, that you have to be kind of tracing everything down the chain and make sure we're not selling in these places?
Yes, it does.
It's not ending up in the places where it's more likely to be misused, or a certain percentage, to go to the Chief Justice's point, are being misused.
Justice Kavanaugh, I think what you've described would qualify under Twitter as general awareness. It would not qualify as specific culpable participation. If you had a manufacturer,
you make baseball bats, and you know they're being used in a particular way in particular areas by particular gangs. And you should, so therefore, we got to make sure that we're not selling to those sporting goods stores that are in particular neighborhoods.
I think that the first lawyerly response is that guns and drugs tend to be treated differently than things like knives and baseball bats. But even that aside, if you knew that your baseball bats
prescription drugs
were being sold into a particular pharmacy, and this has happened, of course, in the opioid cases, were being sold into a particular pharmacy at, in a small town at numbers that were simply insustainable. Prescription drugs were being.
Yes, when they talk about Twitter, they're talking about the Twitter case, and it was Twitter at the time of the case, so they don't change it. If that's what you're asking about the Twitter case, that's why they call it Twitter. Yes, it is X. It's the same thing.
Sold into a particular pharmacy, and this
because remember, Twitter was sued because like ISIS and those guys were fucking using it.
Has happened, of course, in the opioid cases, were being sold into a particular pharmacy at, in a small town at numbers that were simply insustainable, and you knew that you were continuing to sell after being told by the federal government that you were selling into a rogue dealer, and you continued to sell into that dealer, then yes, you would have a problem.
Thank you.
Justice Barrett. Justice Jackson.
But do you concede that you would have a problem or not, depending upon how the statute is worded? I mean, we're in a statutory scheme here. We're not just doing aiding and abetting liability as a matter of common law. Don't you agree?
I do agree with that, Justice Jackson, but I think the fact that we're in a statutory scheme is an important element of centering this case where it is now. That's why I said earlier we are at the beginning of this case.
I understand. I just quickly, in response to what Justice Kavanaugh was just exploring with you, the facts that he laid out seem to me to be covered by this particular PLCAA immunity. That Congress looked at that situation and said, the term qualified civil liability action, which you can't bring in court, means a civil action resulting from the criminal or unlawful misuse of a qualified product by the person of a third party. So in other words, Congress started with Justice Kavanaugh's example. My product is being used by third parties in criminal ways, and they said immunity. So to read the exception to that as essentially capturing the same facts, if you know that your product is going to these people, seems odd to me.
Justice Jackson, what Congress said was immunity unless, and the predicate exception that we've been talking about says immunity unless The manufacturer is alleged, among other things, to have aided and abetted violations of federal gun laws.
Thank you.
That's the important point.
Thank you, counsel.
Thank you.
Rebuttal, Mr. Francesco.
Thank you.
All right, chat. So he's only, you know what? He's only got 6 minutes. His only job now, he's got to land the plane. It's like being in a NASCAR race and you're out in front by like 10 car lengths, and it's just you and only a handful of cars in the lead lap. You just got to get around the track. You got 5 laps to go. Don't wreck is the only thing you have to do. Just get it home.
Thank you, Mr. Chief Justice. Just a few points. First, Justice Thomas, as to one of your questions, if they're right under PLCAA, this would in fact revive the exact same lawsuits that PLCAA was meant to prohibit. If you look at Mexico's complaint, the underlying torts alleged, which is what they're seeking relief on, are.
Yeah, chat. She got gutted earlier about the one-way street, but yeah, they just beat her to death. They just that woman just got beat to death on the floor of the Supreme Court. But you know what? She still made a couple $100,000. She's doing all right in life. I wouldn't mind taking a beating like that just to go in front of I would take a beating like that to argue in front of the Supreme Court.
The exact same torts that were at issue in all of the other cases. The violations only come in their effort to get around PLCAA and fit with one of its exceptions. But if you accept their interpretation of the PLCAA exception, you will have revived exactly the same type of lawsuit that PLCAA was meant to prohibit when they adopted the statute in the first place. Secondly, my friend talked about some paragraphs in their complaint, but I think that their complaint makes quite clear what their basic aiding and abetting theory is. Paragraph 228, and this is an allegation that they repeat throughout. Each defendant's policy is to sell its guns to any and all federal firearms licensees. That is anyone that the federal government says that we can sell to. So their allegation is that we're treating all retailers exactly the same. We're not treating any one better than any other. We're treating them the same. That's important because in Twitter, the court made quite clear that the reason they didn't get across the aiding and abetting line was because there was no allegation that they were treating ISIS, who they knew to a metaphysical certainty was on their platform. They weren't treating ISIS any better or worse than any other customer. Instead, they go on, and this is paragraph 110, to explain their theory. A manufacturer of a dangerous product is an accessory or co-conspirator to illicit conduct by downstream actors where it continues to supply, support, or assist the downstream parties and has knowledge, actual or constructive, of the illicit conduct. I think that's the mere knowledge theory that my friend was just referring to, Justice Kavanaugh. That, however, is the theory that the court squarely rejected in the Twitter case. Turning to foreseeability, Mr. Chief Justice, there was an exchange with my friend on the case law where I think what I heard her say was that an intervening independent act didn't break the chain if it was foreseeable. Well, I would say that that is completely inconsistent with this court's repeated statement that foreseeability alone isn't the standard. It's also completely independent with the Hemi Group case that did not involve a derivative injury. New York City was the only plaintiff that could sue for the lost taxes that New York City suffered. There was absolutely no other plaintiff that would have been able to pursue that remedy and that loss. Yet this court held that the intervening independent act did break the chain. Lexmark is no different. It did not involve an intervening independent act. If I trick consumers into not buying my competitor's products, I've directly harmed my competitor. There is no intervening independent act. As to the various treaties, I would agree, Justice Sotomayor, with your suggestion that the law and the verbal formulations here are kind of a mess. But if you actually look at the cases that the treatises cite for their assertion that foreseeability alone is the standard, they don't cite this court's cases, which is kind of surprising if what they're supposed to be doing is describing the law rather than making the law. But the cases that they do cite principally involve special relationships, like a landlord-tenant relationship or a teacher-student relationship. They don't cite any case in which a manufacturer has been held liable because some criminal unlawfully misuses its product to harm somebody else. My friend again emphasized the Washington Post article. I would urge you to read that article from beginning to end. I think it's very helpful in illuminating how even their theory of mere knowledge doesn't make sense. My friend also talked about 3 pistols sold by Colt with Spanish-named firearms. The notion that selling a Spanish-named firearm is what gives rise to joint purpose with cartels under the aiding and abetting statute is as wrong as it is offensive. There are, after all, millions of perfectly law-abiding Spanish-speaking Americans in this country that find those firearms very attractive, and making those firearms available cannot possibly cross the line into aiding and abetting liability. But even if it could, the notion that selling 3 Spanish-named pistols is the proximate cause of cartel violence in Mexico is frankly absurd, and I don't think it comes even close to establishing Twombly's plausibility standard. My final point is just to step back and talk about.
And chat, we talked about this before, the Twombly standard. That is just a plausible set of facts that have to be pled. Remember, this is notice pleading. You have to plead a plausible set of facts that articulate a basic allegation. And that's why you see Twombly here, the plausibility standard. So remember, this at the end of the day is just arguing the complaint itself was so shitty that it should be dismissed.
What PLCAA was really about. At the end of the day, PLCAA is about protecting Second Amendment rights. It's not just about protecting the manufacturers, the distributors, and the retailers, but it's protecting the right of every American to exercise their right under the Second Amendment to possess and bear firearms. That right is meaningless if there are no manufacturers, retailers, and distributors that provide them in the first place. We ask that you reverse.
Thank you, counsel. The case is submitted.
All right, chat, that's it. That is it. We are done ski. And woo, buddy. Woo, buddy. Yeah. It's rough. This was a rough day for that lady going in there to argue. Imagine having to go in there and argue and just getting buck broken like that. Absolutely smashed and dashed. Absolutely smashed and dashed. Danny Hardesty says, my 686 does not say cartel approved. Yeah. Like I said, we're looking at like an 8-1, probably 9-0 at case. So we'll see what happens there. We'll see what happens. Jefferson Post says, remember to take that like button to Hito. That's your recommendation, not mine. Assholes React is a new member. Thank you, man. Thank you. And guys, we will work on doing a live members only. We're gonna we can get one done tomorrow. We will do that maybe a little bit later tomorrow night. I'm thinking we'll see what the day looks like there, but I do need to make one up for you guys. So we might do one on Monday and do one on Wednesday. Catch you people up, because if you guys are new, if you guys are members, we do some members only here. Get to hang out, have all kinds of fun. And I feel bad when you guys don't get the benefit of that. All right. So Jefferson Post is an industry tactic. Make your argument so dumb and convoluted, opposing counsel has to waste all their time trying to explain it to argue against it. Yeah, but here's the thing. I mean, there's, after a while, like, their argument's clear. Uphold the law. It's always, you have an easy argument when you are saying, Your Honor, uphold the thing as it currently is outside of this court. So the First Circuit has done this, but everywhere else, the Supreme Court holdings are still in effect. So it's like, you're already not in too bad a spot. El Barto says, High Plains Drifter says, hi, Shanbo First Blood. Hello, High Plains Drifter. How you doing, man? Although more like I'd be like the High Plains Grifter, doing all this stuff. But all right. Fatty Caddy's been a member for 5 months. Says, is he able to ask this a PE if she can read? Jefferson Post says, Jackson, every word is different per statute. Yes. With this woman, I don't know sometimes. I don't know. Yes. Winter Soldier says, Budweiser does that to the Indians already. Yes. Vassarus says they check FFL numbers each time they begin sending a shipment. Oh, I know. Everything's already checked. They understand everything. So all this shit they're arguing, they just like argue some gun shops that send me guns and the gun company's like, here you go. It's like, no, there's a whole process for it. Like when I worked at FedEx, like guns would get shipped through, like private people would have firearms being shipped, but also companies and stuff being repaired and like that. Oh my God, there's all kinds of shit that has to be done to ship firearms. Like it's very like the whole process is well documented. So this shit Mexico wants to do. Remember, these are all reheated arguments from like the Brady campaign. So and Giffords and Gun Free America and Every Town for Gun Safety and all this other gay shit that's out there. All that stuff is already out there, you guys. Don't, none of this is new. None of this is a new argument. It's all old. It's all just bleh. But yeah, this is just one of them though, where the Supreme Court is clearly hostile. Even the liberal justices are. They're very hostile. Aaron I just want to bring this back up again. Yeah, this is not everybody in Mexico. It's the Mexican government, and I agree. So I hope you understand. We know that, man. We know that. Mad Rhetoric says, I am far behind, and if you get to this, I'd appreciate it. Could this decision impact the arguments made against firearms companies with regard to domestic issues? I mean, it'll help. It'll just this is just one more case, and this is the thing, guys. If you're anti-gun, this is a bad case, and this bad case is going to lead to bad law for you, meaning it's good law for gun companies in the pro-Second Amendment side. So yes, this is a case that will just be used to further reinforce arguments why the PLCAA should be strong and should be obeyed. So yes, this is bad for the anti-gun side. This is a bad case. Hail to the break for five Canadian loonies or 2.5 toonies, depending on which. It says the biggest issue when it comes to guns here is that you have cities who hate guns and you have everybody else who hunts. Yes. Vassar says, what if Mexico built a big, beautiful wall at their northern border? I know. What if they had border enforcement? Shocker. Yes, KBJ speaks the most words according to many analytical breakdowns of Supreme Court arguments. Yes, she's very wordy. I Take It Good says, why ask Sean to straw buy when you can go to Ireland and get them by the thousands? Well, a lot of those ones in Ireland are buried caches that came through the Libyans, so in the Cold War. So there aren't a ton of guns in Ireland anymore. A lot of them got decommissioned, but not everybody in the IRA decommissioned. Many of them did tell the government to stick their decommission up their ass. Assholes React's been a member for 3 months. Thank you. With saying Jumanji is an idiot and Barrett is a traitor. I'm over it. Yeah, but for this one, Barrett's doing the right thing. Torgo the White says, speaking of Century, do you have any thoughts on the MP5 clones? Well, I mean, the Turk Roach ones are made on HK tooling. The Pakistani ones for a while, I know, like those were the hot thing because they were made on HK tooling. Yeah, I'll take one. Like I'd shoot one. I'd use one. I mean, they're just a little expensive for a fucking MP5, but yes, I'd love to take one of them and make it a SBR and have an MP5 Navy model. I mean, dude, it's like Die Hard. I got a Beretta and an MP5. Life would be good. That said, though, I would run straight magazines on it just because I'm that type of guy. I just think they look cool. Thunder Dragon says it's bad when the liberal judges are not on your side. Oh, yeah. Yep. Jefferson Post says Mexico's not trying to legislate guns. Bullshit. Yes, very true. They're literally using all the reheated arguments, so. Jonathan says Clyde is a total homie for letting you hold him like that. Yeah, Clyde's a pretty good dog. He's a good boy. If you guys go over to locals at potentiallycriminal.locals.com, put it up there for everybody to see. We got some of the we got some early pictures of Clyde. You could see where he came from to where he is, and some early pictures of Lainey. She's come a long way too. So potentiallycriminal.locals.com, you can see that over there. Fatty Caddy says, I was wondering if you were happy to see me, or that was just a sandwich in your pocket. Well, you're going to have to shove your hand in there to find out. Assholes react as too many grays in here. About to send some grays to the green. Very good. Thank you so much, Whiskey. I appreciate it, man. Sushinoko Z says, are they thinking of HK? I don't know. You're telling me skip to the K31 and get the PE57, big boss. Yeah, PE57s are pretty fucking pricey, especially after they started getting popular. But yeah, I think those would be, I'd be neat to shoot one. They just look weird. Terabus says straw purchases aren't all illegal. If like there's very limited exceptions, but there's a United States Supreme Court case, US v. Abramsky, where the guy was a cop and his father-in-law wrote him a check saying for purchase of a Glock on the memo line. Now that's how fucking boomer that guy was. Abramsky got convicted because he was a cop. He used Glock's Blue Label program, which is a discount program. He got like $50 off the Glock purchase, bought the gun, turned around and gave it to his father-in-law. That was considered a straw purchase under federal law, even though they both were allowed to own it. Yes. Thomas laid that whole thing on top of her Coke can. Yes. Yes. Would I be willing to let the lawsuit go forward and possibly cost a gun maker a lot of time and money if it changed Wickard v. Filburn? No. No. That'll get done in its own time. I'm not going to let the Second Amendment take a hit like that. Yeah, Kavanaugh's Gutner. Yes. Any chance Nick will face additional charges? From what I understand, it's still being investigated. So not sure. Not sure. Timmy Carl says, will you look at the AB 133 bill in California? We did on Thursday night, and I might take more of a look at it to see what's going on. But yeah, it really destroys the ability of self-defense for people. But yeah, I'm working on that. We'll get that probably broken down so it can be done as a release as a standalone video, Timmy. But yeah, we'll work on that. Thank you for the super chat, by the way. Sean bet she feels like Lily Phillips after a day at work. Yes. Let me see here. Brooke Secret says, crap, I'm gray. Yes. Edward Scott says the gun went through a dealer of the background check of the Abramsky versus U.S. case too. It was all kinds of fucked up. Yep. Guy went through an FFL, filled out a 4473, and even though everybody's legal, the Supreme Court said that's a straw purchase. So that's why I'm saying, like, you guys are like, oh, there's all kinds of exceptions. Very limited ones. And Abramsky's bigger issue was he got indicted for other federal crimes. So don't fuck around. Like, you got to be very fucking careful about what you're doing. I thought you're allowed to buy guns as gifts. You can. The best thing to do is just shut the fuck up about it when you're buying them, because most gun stores aren't going to bother with it. When they hear you say, oh, I'm buying it for someone else, that take it right away. You know what? Fuck it. They'll take their chances. If you're going to buy a gift for somebody, don't fucking say anything about it. Buy it, shut the fuck up, and walk out the door and just go wrap it up and give it to somebody. That's my advice if you're going to do that. Don't fucking tell anybody about it, because, it just... Because if I was advising a gun store, I would tell them, don't even bother. How do you know it's not an ATF trying to sting you? You don't know. So, Ohio Clyde could share my foxhole, bro. Well, is there another Clyde? There's only one Ohio. There's only one Clyde. Yes, there are exemptions in 21A. Yes, there are. I understand there's exemptions, but if I'm advising a gun store, there's nothing wrong with saying, we're not fucking doing that. Just buy the fucking gun, shut up, and give it to somebody. If you're talking about doing it, I'd tell them be suspicious of an ATF sting. Captain RB says, what happened with the cop? He just ran his mouth at the counter. No, he was investigated for being a dirty cop. That was the problem. He was being a dirty cop. And as they were digging through stuff, they found a check with the memo line, for purchase of a Glock, for buying me my Glock or something. It was some retarded boomer shit on the memo line. And they went and checked and they jammed him up with it. So. The ATF will set you up. I had to deal with that one time. I know. I've heard the stories, guys. If you ever go to the gun store, every once in a while, the ATF will have one of their informants or an agent standing out there saying, "Hey, man, will you buy a gun for me?" And I know somebody that happened to, and they immediately walked in and they called the police and said there's probably an armed felon outside because they were like, and the police showed up, and yeah, that caused a lot of problems. So it was good. They had an agent call and assist. We sold his buddy a full auto kit for an AR-15, and he wanted to. Yeah, that's the thing. That's why when you hear people talking about buying things for somebody, it's probably just best to go, not doing it, not doing it. Squiz Guy says buying the gun a month ahead. Well, you can do it as a gift. You just don't tell the gun store you're doing it, and you don't have to do it that way. You don't have to do it that way. I've had a gun gifted to me before, and I thought it was great, and it was legit, bought new and everything. It's just you don't fucking talk about it. You just don't fucking talk to everybody about it. You know, it's like, first of all, lower your voice. Buying a gift card's the other way too. Did I see Sig Sauer seething on Twitter about the P320? Yes. And the biggest problem is they still have their voluntary, like, the gun will go off upgrading program. So, you know, Sig Sauer is coping, yet they admit their gun's fucking defective as shit. Jim says maybe we get really lucky in this case causes a concurrence that says the GCA for licensing is unconstitutional. Yeah. I mean, I'd like that, but remember what I said. Like, the Supreme Court's not going to vacate all gun laws, and they're never, you know, we're not all getting machine guns. So I don't think they'd ever let that happen. They would avoid that at all costs. I would like it, though. I would like it. I agree. Jefferson says, hypothetical, pay for the gun, then have the other person go to the store, fill out the forms to pick it up. Similar to the gift card way. Yes. And Vassarus, this is the best way to do it. The best course for this is have somebody do the check and you pay for it. Yeah. As long as the person who's actually filling out the forms, like the easiest way is like, I'd like to buy like a gift certificate, you know, and like you pay for it and then they buy it. Like there's ways they're willing to do it, but it's going to be documented. So that way they're not getting fucked. So yes, that's for the drop safe issues on the trigger. I know, Nadata. But the problem is, like, it also, the gun still goes off. Like, it's, if you get this fixed, the gun just going off is still out there. Can you buy a gift card with crypto? Depending on the place, they probably let you. Could you buy a gun with Stoney's gift cards? I don't know. Oh, it's not drop saving without the drops. I know, that's the problem. So it goes off on its own. Some gift cards will decline on gun purchases. Discover is bad for this. Ooh, I did not know that. That sucks. Sounds like we got somebody who's an FFL or works at a gun store. Yes. Oh, Jim is saying they're older imports of SP5s that are pricey because they can take the trigger packs. Yes, that's true. Sig Issue was making polymer and moving production out of Germany. Well, that, but also they were fucking around with trying to be as, you know, non-Glock as they could, and they just did really shitty engineering. So, yeah. No, Iman Reza saying, could I take my Stoney's gift certificates and pay for a gun and trade? That's what I think he means. Is a Baldo drop safe? I mean, it depends. It depends. Is it there? I don't know. Axis Hampton Dellinger just filed to dismiss his case. We did this yesterday. Like, buddy, like, you're hurting my feelings. You're hurting my feelings. We talked about this yesterday. You know, we did a whole show. Like, no, like we had a, hold on here. I gotta bring this up. Like, we had a whole show about Hampton Dellinger quitting on Thursday. Like, we did the whole thing. You didn't even watch Thursday, did you? You were never there. You never went to my piano recitals. Oh. But yeah, he filed to dismiss the case, and the DOJ's like, we're going forward. If you win Naked Twister, Stonies will give you gift cards. Yes, they will. And SIG found a way to legally sell select fires. Yes. Yesterday was Friday. Yeah, I keep forgetting today's Saturday. Fuck, and it sucks like that. So, no, this isn't the same thing. Okay, well, I don't know what he did in the meantime because he already made a press release saying he wanted to quit. Let me see. Let's see what this is real quick. Let's see here. Let's see. Hampton Dellinger. Let's see if he did a new filing today. Yeah, he released a statement saying he wanted to quit. Yeah, I don't see the new thing what you're talking about, guys. Yeah, he filed a motion, but he already did his press release, so yeah. So I don't know. I mean, there's not much there. Oh, what's this summer going to be like for rioting? Oh, we're going to have some riots too. We're going to have some riots too. So daylight savings tonight. Oh god, that's gonna suck. Losing an hour chat. All right. Oh god. So no more USAID. How are they gonna riot? I mean, that's the thing. There will be no more pallets of bricks for them to go after. There will be no more pallets of bricks. That is going to be tough for them. That will be so very tough. I just don't know what they're going to do. I just don't know what they'll do. All right, chat. So we are going to get ready. We're going to, we are going to open up here. We're going to do some IL2 stuff. We might watch some Flashcast as we're working here. But let's see what we're on part 2. We're on part 3. Okay. So we need to do IL2. Sorry, chat. I got to open up Photoshop and do set this up because we're going to go right over into that pretty much right away because it's kind of late and I don't want to go too late tonight because we're going to lose hours of time. So I don't want to do it like that. I don't want to do us up like that. So we're going to hit that up here. So if you guys want to join us, we're going to go over and do some model stuff. We are working on the IL2 Sturmovik and take care of that. So in your pile of shame, is there a Lego kit? There's some like one of the Lego flower things. So you guys want to, we'll snipe MG Law. Yeah, so what we're going to do, chat, we are going to do, so hold on here. So here we go, chat. All right, here, let's see. We're going to set it for 11:30. I just need a couple of minutes to get caught up and sort. I need to clean up and take care of some stuff. So just give me a minute, chat. And we'll get started because we got a lot to do, chat. We got like the wings partially put together. We got to do a little bit of airbrushing because check out this blue we're doing. That's a pretty solid blue color. We got a nice setup that we're working on here. So I got a crap. Well, that's among the other things. So, all right, chat. So we're all done. Like I said, I wanted to show you guys this because this one is a BTFO moment, and I thought it was going to be some easy, good listening. Somebody had already told me from listening to it that they're dead in the water, which is good to know. So, Safa, Mexico, Safa le Mexico, Ralph's new homeland. They have to suffer. But we are going to move on from here, chat. So, guys, until next time, and really, we're going to be over in the model stream. Just because you did it does not mean you're guilty. And that includes the gun manufacturers. They're not guilty. They haven't done anything. Not their fault. They ain't done nothing wrong. They didn't do nothing, chat. They didn't do nothing. And that's always critical. Didn't do nothing. Thank you. If you guys are new here, please give me a like and subscribe. I would appreciate it. But I will see you guys next time. So take care, everybody, and good night.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick hated yelled at? Why, yes it was.